All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Mr. Knops, you still have the floor.
Thank you, Mr. President, Your Honors. My last part relates to the defense case as to the role of Mr. Ngai and the relevance thereof for the alleged individual criminal responsibility of Mr. Ngai. You heard this morning, Mr. President, Your Honors, that it's our case that Mr. Ngai was not a member of any alleged inner circle or contributed or assisted in any crime with a group of persons acting with a common purpose. Now, the next question this trial will touch upon is the question whether there was a criminal purpose or policy at all to reinstate François Bozizé into power. It's a prosecution case, as expressed by its opening statement yesterday, Wednesday, that Mr. Ngai role was, I quote, more distant. But we submit that this qualification of the prosecution of Mr. Ngai role as more distant is quite an understatement. That Mr. Ngai, and I quote the prosecution in its opening statement, did not get his hands dirty and operated under the radar is, as we submit, a total mischaracterization of his actions as demonstrated this morning and the intent attributed to him in this case. It's our case that no common purpose or criminal policy existed as alleged by the prosecution, and that the role of Mr. Ngai as more distant, quotation of the prosecution, cannot constitute such a criminal responsibility. This trial will establish, as we submit, Mr. President, such an objective or common purpose or plan, if existed at all, is ab initio not deemed criminal at all under international criminal law, nor the statute. The court should be mindful of the majority opinion written by Judge Henderson, rendered on the 16th July 2019, in the acquittal of Laurent Gbagbo et Charles Blé Goudé, where the majority of the chamber found that Mr. Gbagbo or Mr. Blé Goudé may have shared the goal, together with other individuals, to maintain the former in power, but this is immaterial. What matters is whether or not there was ever a plan, albeit an implicit one, to commit any of the crimes charged in order to achieve this goal. So a potential plan, if existed at all, to reinstate an individual into power is not criminal under international criminal law, not the statute. It's also, by the way, rendered this decision in the case of Brima et al. Of the Special Court for Sierra Leone in 20 June 2007, where the judgment in that case was rendered, and there you see the same approach as delivered by the majority opinion in the case of Gbagbo Blé Goudé. Now, Mr. President, Your Honors, the prosecution theory and case will ask you to make a speculative leap by stating and by accepting that by virtue of the fact that they were members of the same ethnic group and family close to each other, that this would constitute an inner circle. The evidence at trial will not support this at all. You will hear testimony, even from prosecution-owned witnesses, who told the investigators that Mr. Ngai and Mr. Bozizé were not related at all. The fact that he and Mr. François Bozizé were both Gbaya cannot justify the inference of any type of familiar proximity to support the case of the prosecution that Mr. Ngai formed an inner circle based on this assumption with Mr. François Bozizé, or Maxime Mocom, or Bernard Mocom, or any other person. It would mean that all Gabaya from Western Africa could have been part of this so-called fictitious inner circle. Speaking about fictitious concepts such as inner circle, the Chamber should, in our submission, be aware during this trial that François Bozizé and Patrice Ngai were not part of the same family as suggested by the prosecution in this case. Were not part of the same family. The parents of Mr. Patrice Ngai originated from the village Bowara in the province of Nana Bakassa, while the parents of François Bozizé originated from Benzambe, from the province Bossangoa. Lastly, speaking about fictitious concepts as inner circles, with respect to Mr. Gassona's alleged ties with the KNK, the party of François Bozizé, the chamber should be aware that a prosecution witness told the investigators during the investigation that while Mr. Gassona was indeed a member of the KNK, he was never a KNK activist really. Document 32 of our list of material. He was never a KNK activist really. He was more of a businessman. These were the words of a witness which was interviewed by the investigators of the prosecution. Now, Mr. President, I touch upon another question in this trial. This trial will also revolve around alleged meetings. You will hear in the prosecution case a lot of evidence about alleged meetings. But were there any meetings within the confines of an alleged inner circle? If there were any meetings, Mr. President, Your Honours, it is our case that any such meeting between Patrice Ngai, François Bozizé or Bernard Mocom or whoever were not meant to set up a common plan or purpose. The prosecution, of course, wants you to believe otherwise. But it is not what the evidence will tell this chamber. Rather, it will tell the chamber that Patrice Ngai did not follow Mr. François Bozizé, as we said this morning, to Cameroon, to join him there in order to conceive a plan or policy to conduct military operations. Not at all. We will show you that he went there, Mr. Gassona, to Cameroon, simply to do what thousands of Central Africans did at that time, to escape the war, to save their lives. You will hear a witness who told the Office of the Prosecution that, I quote from the French transcript, ils se sont rendus.
They went to those countries undoubtedly to find refuge.
Document number 9 of our list of materials. And your chamber will ask
They came to the country to seek shelter.
And your chamber will ask yourself during the course of the trial, why Cameroon? Why were all these people going to Cameroon? The answer is very simple. We don't need a trial for this answer. Cameroon is a logistical choice given its proximity, economic ties, and the fact that its president at that time was favorable to accepting refugees from the CAR. There was a common language, French, which was also spoken in parts of Cameroon, and witnesses from the CAR speak of how they have family in Cameroon. Mr. President, Your Honours, you will also learn during this trial that Mr. Gassona fled to Cameroon like thousands, not to join François Bozizé, as we said this morning, but simply for the survival of himself and his family. A prosecution witness told the investigators that Mr. Gassona was indeed occupied with his football obligations for the Federation in Cameroon while in exile, and therefore was only able to meet him, Mr. Gassona, because of his occupation 3 or 4 times in Cameroon, document 66 on our list. All this implies, and will imply to the chamber throughout this trial, Mr. President, that no coordination on part of Mr. Gassona took place in Cameroon within the confines of an alleged common plan. It's our case that if any meeting abroad materialized, it was merely to speak about the political situation in the CAR, which was dramatic. The foreign fighters, which was supporting the Seleka, committing crimes. And we believe that the prosecution evidence will also support this stance. You will hear testimony from a prosecution witness, witness number 9 on our list, who will confirm that all people from the car who found themselves in exile in Cameroon were like brothers. Brothers from the car meeting to exchange ideas and discuss the dramatic developments in their home country, what was happening there with their lives, and what could be done to restore peace. Document 66 on our list. Mr. President, this hardly will allow any inference to be made that Mr. ssona was part of an inner circle joining Mr. Francois Bozizé in Cameroon to formulate a common plan or purpose whatsoever. Now, of course, the Chamber will ask yourself, will this trial show any tangible evidence to this extent? It is our submission at trial that no tangible, objective evidence will be established that Mr. ssona coordinated any military action, not being a military man, any military action from Cameroon being part of an alleged common plan or core alliance, another fictitious concept you will hear during this trial. The prosecution will, during this case, try to believe you otherwise and will present also CDR evidence to this extent. However, this material, as we believe, similar to the Facebook evidence, will not reveal any concrete, tangible evidence as to Mr. ssona's purported role. When you face, Mr. President, Your Honors, during this trial with this CDR evidence, we will ask you to keep in mind, what already the pre-trial chamber in paragraph 180 of its confirmation decision ruled about this issue, simply saying, look, the chamber observes that such records do not provide the court with any kind of indicia as to the content and purpose of the conversations. They only allow the chamber to establish that Mr. ssona had conversations with such persons. This is, of course, the reality of the evidence, Mr. President. And we ask the chamber to come to the same conclusion as the pretrial chamber did with the CDR evidence. The prosecution asks you to infer from that evidence the alleged role of Mr. ssona. But when you hear this evidence from the prosecution during its case, we also ask you to take notice of a report, an interesting report mandated by the Office of the Prosecution itself. I will not mention the author because of the confidential nature of this document. You will find it 113 on our list of material. And we intend to introduce this at trial because, Mr. President, this report highlights in its findings, this expert, the shortcomings of exactly CDR data provided by the prosecution. It notes, inter alia, the significant differences in formatting source data. It refers to uncertainty with respect to the quality of data, etc. This document, Mr. President, will convince the chamber that CDR evidence is not only of a highly unreliable nature, but cannot lead to any inferences as to the role of Mr. ssona while in exile in Cameroon. And during this trial, you will hear qualifications such as inner circle, core alliance, meetings, planning military operations, etc. There will be no tangible evidence as we anticipate. Of course, you will hear many so-called insider witnesses appearing before this court, presented by the prosecution, saying that Mr. ssona participated in such an alleged plan. Of course, you will hear those witnesses coming before you. You will hear from those witnesses also, and one of the very few witnesses who alleges that Mr. ssona attended such meetings with Mr. Bozizé and his so-called entourage in Cameroon, witness 8. But that witness will not confirm that he in fact attended the alleged meetings himself or herself. When hearing this type of evidence, Mr. President, we ask the court to keep in mind that another prosecution witness who will be presented to you to back up this allegation about the content of these meetings will be, as we will submit, a person of a dubious character who has previously committed crimes against the administration of justice before this court. I will not go into detail because of the confidential nature of this issue, but the court is aware of our filing in this regard. Mr. President, we started our presentation this morning with Mr. Gassona's background, and not without reason. We ask you to look at his life in those days, and we ask you to conclude that he could not have reasonably assisted or contributed to the crimes charged, or have been part of an alleged common plan. We believe that the evidence will show also that his personal life, his activities as president of the Football Federation Central Africa is a clear contraindication of the OTP's case. We'll just give you one example today, one example. The evidence shows that on the 1st December 2012, Mr. President, Your Honors, Mr. Gassona traveled to Japan for the FIFA Club World Cup. Looking at Mr. Gassona's electronic ticket to Japan, for instance, you will learn that in addition to a mission order that clearly states that he is to complete an 18-day mission in Japan for the purposes of attending this cup, you will find evidence that, which by the way contraveils the assumption that he was involved in the activities of Kokora in December 2012, as the prosecution's case submits to you also in its pretrial brief in paragraph 556. We direct, by the way, the chamber to the items 48 and 49 of our list of materials, where you find also the evidence to support this travel of Mr. Gassona to Japan. But you will see that after this 18-day trip to Japan for the FIFA Cup, Mr. Gassona arrived first in France, where he spent Christmas. We're still in December 2012, where the prosecution says December 2012 was the creation of Kokora. And Mr. Gassona was instrumental in those activities in December 2012. So we'll see, this man, traveled on the 1st of December to Japan for the FIFA Cup, and then, after 18 days, spent Christmas with his family in Paris, traveled through Cameroon, and only returned in Bangui on the 27th December 2012. 27th December 2012. Document 52 on our list of materials. Now, Mr. President, Your Honor, this is to say this trial will provide you tangible evidence, objective evidence, not evidence of witnesses who were not there, that he, Mr. Gassona, did not return to Bangui till upon the 27th December 2012. And we refer to his passport pages you find, as I mentioned, in our document 52 of our list of materials. This type of evidence, Mr. President, will already countervail the prosecution case that Mr. Gassona was involved in realization, the foundation of the alleged common purpose, by mobilizing the youth and supporting them by the creation of Kokora in December 2012. He was not even there. Very simply. Now, another relevant question the prosecution will raise, and also the defense will raise during this trial, is: did Mr. Gassona finance the anti-Balaka? Our answer is also here: he could reasonably not have done so. We'll prove this in court. We will choose evidence to show that his financial situation at that time is a clear contraindication for the prosecution case. Because we will show you that in 2013 to 2014, Mr. President, Mr. Gassona was in dire financial need. It's not just our word. The prosecution is in possession of documents indicating that Mr. Gassona indeed was in dire financial problems in those days. We refer simply for today to document 53 on our list of materials. It's an email of 7 September 2013, so 3 weeks before October 2013, and this is the time frame within which the prosecution says Mr. Gassona started to finance all these groups from October 2013. This email of 7 September 13 is an email from Mr. ssona to another person where ssona lists his huge financial struggles and asks for financial help. Another email you find will be the one of November 2013, so a few weeks after October 2013, where Mr. ssona expressed his concern for not being able to even pay the fees for his son's school. Mind you, document 56 on our list. That's 55. 56 is another document asking again, Mr. ssona asking again for financial assistance for January 2014, before leaving to Cameroon. Now, Mr. President, these documents, just a few examples, which are to be found amongst the prosecution evidence, will make it quite probable already that he was able to dispatch money, as the prosecution asserts, to the field in the fall of 2013, October 2013, as the prosecution submits in its case. Given that at that time, Mr. President, the evidence will show that Mr. ssona was struggling to even provide financial need for his family. Now, the question is, why was Mr. ssona in dire financial need when leaving Cameroon in 2013? We will give you this answer also at trial, because he had at that time, mind you, almost 30 family members, 30, who were under his financial responsibility in Cameroon. In addition to these 30 family members, you will learn during this trial that also other people were under his financial responsibility, including his father and other family members in Bangui, as well as family in France. A huge family, and this man had all the financial responsibility to take care of them. His situation financially was even more burdensome, since his two younger siblings, namely his brother Barnabé ssona and his sister Angele ssona, were both seriously ill at that time. They were on the verge of dying and dependent on Mr. ssona for financial support and obtain medication they imperatively needed. Sadly, Mr. ssona lost both of them in Douala in Cameroon. They died, despite Mr. ssona trying to help them with medication. Now, Mr. President, this is all to say that the evidence will illustrate at this trial that Mr. ssona did not have the financial means to finance all these anti-Balaka groups. Documents will show this court that he was himself asking for financial help from friends and family in order to take care of his huge financial responsibility towards his family. It will undermine the prosecution case. We will show you that he even requested in those days financial assistance from the FIFA and from the CAF to help his subsistence while in exile. We will show you that in Cameroon he set up a special bank account to receive those emergency funds in Yaoundé to survive. As a result, we will ask the chamber to negate the portrait of Mr. ssona as being a person capable of funding all these different anti-Balaka groups. And we'll submit that the prosecution case will lack forensic evidence based to suggest that any purported payment attributed to Mr. ssona could be linked to an alleged common purpose. Indeed, Mr. ssona, as we demonstrated this morning, even when in great financial need, was still a man with a heart. Generous as he was, he still helped other people of the society despite his financial needs. It's quite self-explanatory that one witness told the investigator of the prosecution, document 66 on our list, that ssona gave me in those days 100,000 CFA, that's 153 euros, Mr. President. And this witness told the Office of the Prosecution investigators, he does this out of the goodness of his heart. He helped a lot of people like this, including pensioners in Bangui. The chamber will not hear, as we submit tangible evidence, to link the financial means of Mr. ssona, if any, to a common purpose or to show that he in any way contributed to the commission of the crimes charged. We also ask you during this trial to pay attention to the witnesses who told the investigators of the prosecution that ssona indeed gave, despite his financial problems, gave money to those people who were hungry and to stop them from committing crimes and to enable them to return to the provinces. It had nothing to do, these payments, with any common criminal plan or purpose. And why would Mr. ssona act in this way? Why would he even pay money to help these people while his family was in dire needs, financial needs? It was, as you heard this morning, it was his nature, it was his personality. In any event, these actions will clearly contradict the prosecution case, specifically when it concerns Mandrea. The court should keep in mind that in those days, the government of the CAR didn't pay any individuals to return to their villages, to lay down the weapons in their villages. And it was indeed Mr. ssona who stepped in sometimes with his even poor financial means. One example you find on our list of materials, number 58. To conclude, Mr. President, Your Honors, this trial will tell you that Mr. ssona did not fund the anti-Balaka movement because of his own financial situation. Now, another question is, did he provide weapons or ammunition to those anti-Balaka individuals? We believe this trial will answer the question with a clear no. The Chamber will not hear evidence, as we submit, about weapon storages, nor Mr. ssona's involvement therein, nor any concrete contribution of weapons to anti-Balaka groups by Mr. ssona. To the contrary, the evidence to be presented at this trial will show the Chamber that those anti-Balaka in those days fought with basic weapons, such as artisanal, traditional hunting weapons, machetes, wooden sticks, etc., some of them even unarmed, or weapons retrieved from Seleka fighters, as some of the prosecution witnesses will tell you, document 59 of our list, or retrieved from the Faka during the attack. Your Honors will learn during this trial that the weapons in the possession of the anti-Balaka were indeed mostly retrieved from Seleka fighters. But all of this had nothing to do with the role of Mr. ssona. One prosecution witness told investigators that the resistance, the anti-Balaka, had a strategy in place to acquire weapons. The strategy to acquire weapons was to attack and neutralize the Seleka. That was the way how the anti-Balaka armed themselves, Mr. President, not through one individual, Mr. ssona here, in his current, at that time, situation financially. The evidence to be presented at trial will also make clear to the Chamber that the coordination in Bangui did not provide weapons or ammunition to any fighter. Prosecution witnesses, as we believe, will be heard by the Chamber and will be established that Mr. ssona himself nor the coordination were involved in the providence of weapons. And when it concerns the 5 December attack, there is even a prosecution witness who was initially on the list but was withdrawn, who told the investigators that the military weapons they used during the attack on 5 December were Faka weapons and were not provided by anyone, neither in Gobert nor during his journey of that witness to Bangui. Therefore, the prosecution case that Mr. ssona was instrumental in the armament of those groups has to be dismissed. And these are not just our words, because we believe that several prosecution witnesses appearing before this court will confirm this and already told the OTP investigators that the coordination did not provide weapons or ammunition to any fighter. The Chamber should be conscious of the fact that one anti-Balaka leader who was already interviewed by the investigators but was not provided with a pseudonym and not appearing on the list, also told the similar message to the Office of the Prosecution. I quote briefly from that transcript. In French, he told investigators, donc ne pense même pas que je fais.
So don't think I'll give you a penny to buy ammunition or to go kill.
But who told this? It was Mr. Ssona. This witness told the investigators of the prosecution that it was Mr. Ssona who told him this, that he shouldn't think that he will give one dime to this witness to buy weapons or ammunition for killing. It was Ssona who told this to the witness of the prosecution. Mr. President, document 95 on our list. Mr. President, a man is put on trial today who was appointed to coordinate peace in his country. Was a coordination necessary? Yes. But why was he put on trial? Because this coordination was necessary for the peace process in light of the diversity of all the anti-Balaka groups. One needed a person, the community, the government needed a person to structurize the peace process. And it should have been someone neutral, not a fighter, words of the prosecution witnesses. And there was only one man in the country who could save the country from burning down, and that was Mr. Ssona. And it was not to structurize pre-existing groups to commit crimes. It was to facilitate and streamline the process, to bring the leaders from the provinces to Bangui, to the peace table. Now let us have a closer look at his task as a national coordinator. His only contribution was, Mr. President, Your Honors, that he gave the anti-Balaka a voice to unify the country, to represent them before the government and the international community. And Mr. Ssona accepted that position on the condition that the violence would cease. You have seen today some of the evidence to this. His role was simply limited to conveying the anti-Balaka's demands to the government or the international organizations. There will be evidence presented by the defense that Ssona in those days even sent letters to the Secretary General of the United Nations to ask for help. It was Mr. Ssona who reached out to the United Nations in those days, Mr. President. And you have to keep in mind that when he returned in Bangui in January 2014, Mr. Ssona, the movement, the anti-Balaka movement, was well under its way. It was irreversible. It was only to stop with a person. And these are not just words of the defense. These are also words of prosecution witnesses who will appear before this chamber. Witness 26 on a list of evidence of witnesses will show this. Mr. President, at this trial, we will observe that as a national coordinator, Mr. Ssona's incentive was solely to unify these groups, to give them a voice and a face at the negotiation table, to gain peace in the country, using his philosophy as sports, his experience and drive as sports to unify people. None of us in this courtroom were present at those meetings, Mr. President. None of us. Some witnesses were, indeed, maybe. We will hear that during the trial. But one of the witnesses who was interviewed by the Office of the Prosecution and is not appearing anymore on the list, told the following, and this is very important for the chamber to know at the outset of the trial, told the following to the investigators about a meeting. He said the following to the investigators, Mr. President. During the meeting, Ssona took the floor and said that if they wanted him as a leader, all the exactions had to stop. That everyone had to follow his orders, stop pillaging and killing of Muslims for nothing. This was said by Ssona according to a prosecution witness during these so-called meetings. It had nothing to do with concocting crimes, Mr. President. What this person also told the investigators, Mr. President, Your Honors, was exactly what we discussed this morning with your court about the personality of Mr. ssona. He said, when the young people wanted to rise up, the government would call ssona. He didn't volunteer to be in this courtroom as a national coordinator. He was asked to assist the government in the community, to speak with them. The government would ask him, according to this witness, would ask him to talk to the youth to calm tensions. That was the mandate he was asked to perform, Mr. President. Document 64 on our list. Your Honor should be aware that according to this very witness, some of the anti-Balaka, because Mr. ssona refused to engage in fighting, even tried to target him and his family. His house was burned down in Boirabe. They tried to kill him and his family, Mr. President, because he was refusing to take up arms, Mr. President. And this will also be detailed by witnesses, Mr. President. Document 64 on our list. Your Honor, when hearing the evidence, your chamber should also be aware that one of the witnesses who contact the investigators exactly told the same as we just telling you during our opening statement. And he also told that some of the efforts to coordinate with the provinces for the purpose of the DDR process did not always work out because, and this is important, because it shows the lack of any central control to monitor the anti-Balaka. Because, I quote from the French statement, chacun déjà,
everyone in that little group already claims to be the leader of his group, and that he didn't have to report to anyone.
This was the reality on the ground, nothing else. This is the evidence which is direct, and not experts who will testify before this court, reconstructing the conflict years later. These are the witnesses the court needs, and some of them are unfortunately withdrawn from the list. Mr. President, this trial will also address the question whether Mr. ssona gave any instructions or orders to so-called com zones, especially with respect to military operations. No, there will be no evidence to this. Mr. ssona was not a military man. It's our case, and we will show that he was not involved in any type of military operations. The prosecution wants you to believe in this case that he communicated from Cameroon about military operations. Here, we should not confuse the evidence, Mr. President, Your Honors. Of course, like everyone, Mr. ssona was very much concerned about the fate of his country. And he received many proposals and suggestions from individuals who were equally concerned about the attacks on the population by the Seleka. We ask you to keep in mind, when you hear the evidence of the prosecution, that any allegation that Mr. ssona responded to such communications, to such requests for assistance, cannot serve in this context as proof for alleged criminal intent. A clear example which we will show at trial is his concern and at the same time the lack of intention to be military engaged. There were his actions versus the international community. I'll already mention them. We will show you with evidence that he in 2014 addressed the crisis in an official letter and communiqué and a proposal for a solution to the Secretary General of the United Nations. Mr. ssona, Mr. President, is a man who never left the path of diplomatic dialogue and never entered the path of military action. This was the reality on the ground, Mr. President, nothing else. And we will show you, contrary to the prosecution case, that the purpose of the missions he might have given to some of the anti-Balaka was simply to disseminate the peace process in the provinces, to convey the content of the coordination discussion in Bangui, to be his voice, the voice of peace and reconciliation with the government and the international organizations. These so-called instructions which would have been given by the coordination and Mr. Ssona in particular, were in reality therefore not related to any military operation at all. Even, you heard him saying, he tried to stop the erection of roadblocks. He asked for the removal thereof. It was in line with his personality. He was concerned with the existence of roadblocks and tried to help to remove them. The chamber should be aware that the fact that ssona helped in dismantling the barricades in July 2014 was acknowledged by the prosecution in its pre-trial brief. You have undoubtedly read this in paragraph 481 of the pre-trial brief. The prosecution accepts that Mr. Ssona helped in the dismantling of the barricades in July 2014. Also, prosecution witnesses will appear before this court who will confirm this, who already told this to the investigators of the prosecution, document 89 of our list. Now, in this trial, we will argue, Mr. President, Your Honours, that his calls to take down roadblocks, which is confirmed by the prosecution, there's evidence, in his capacity of peace coordinator, can of course not serve of evidence that he had the power to erect them. The fact that you try to dismantle them does not a fortiori mean that you have the power to erect roadblocks. That is an illusion in a court of law, Mr. President. In conclusion, Mr. President, we will illustrate in our case that Mr. Ssona was vividly against any violent practice, including that of the setting up of barricades for the purpose of racketeering or any other crime. But it was beyond his control and abilities, of course, to stop it in such a huge country as we explained this morning. We have three final questions to conclude my submissions. First, was he involved? Is there evidence that he was involved in the attacks? No. The chamber, as we are convinced, will hear no tangible evidence to the extent that he, Mr. Ssona, called for or ordered to launch any attacks whatsoever. You might hear a witness saying that Mr. Ssona was informed of the attacks, but this, of course, has nothing to do with the power to stop them or to give instructions. The type of information enabled Mr. Ssona in those days to inform the authorities so that the international community would be aware of the actions and the developments, document 80 on our list. Second question, will this trial establish that Ssona gave orders or was capable to do so? Also here, the answer will be a negative one. It is our submission that the court will hear witnesses who told the investigators of the prosecution that he did not give any direct order for crimes committed to the respective zones. Now, what about summons? Was he able to summon zone leaders? The answer also here will be negative. The chamber will have noticed that the peace case rests upon the assumption that Ssona was allegedly able to summon the zones to attend meetings. That he was able to summon zones from Bangui and the provinces and attend the meetings. Now, during this trial, it will be established that these meetings were certainly not regular and that all the zones were simply invited. Mr. Ssona had no power to summon. He could only invite those leaders, which were leaders in itself. We just heard from a prosecution witness. We anticipate that this witness will come before this court. He invited them to merely attend meetings in the context of the very specific peace-related events of the DDR, such as the Brazzaville Forum, the preparation thereof, etc. The court will hear in specific one witness who told the office of the prosecution that the number of coordination meetings between January and October 2014 were just 4 or 5. At least 3 of them where the zones were invited. He speaks about invitations and not summoned. The evidence will therefore show that the preparation for the Brazzaville talks and the meeting related to the Bangui Forum were based on invitations of the respective zones. I conclude, Mr. President, this part by saying that the Chamber will be convinced that at the end of the trial, Mr. ssona cannot be blamed for issuing any orders or summons to the respective Comzone leaders. That all the meetings pertain to peace activities and that he would not discuss any military operations with those respective Comzones. He would just pay for their transport, without which there would be no peace talk at all. Document 59 of a list of materials. Finally, will this trial establish that Mr. ssona dismissed information, disregarded information by doing nothing, or actually denying the anti-Balaka's responsibility? Well, that's not a valid question if we assume and accept that he was not instrumental at all in the anti-Balaka movement. But apart from this observation, the answer is no. This prosecution case will be unraveled also on this point. Far from not reacting to the reports of crimes allegedly committed by anti-Balaka, the evidence will show that Mr. ssona did actually everything in his capabilities at that time to stop them. The court will hear at this trial that far from dismissing or disregarding the information on the reports of crimes committed by anti-Balaka, alleged anti-Balakas, the evidence will show to this chamber that Mr. ssona, to the contrary, called for full cooperation with the international forces and the cantonment or confinement of the anti-Balaka's actions as to guarantee the disarmament and also the sending back of those units and individuals to their regions of origin, document 92 of the list of materials. We will even show that he actively sought the removal of a senior or prominent member of the anti-Balaka because he was not able to abstain from any violence. The evidence showing that he, Mr. ssona, personally thought that these exclusions were necessary of those individuals from the peace negotiation table, and is convincing proof that he did everything within his abilities, taking into account that decisions by the coordinations were not unilateral to be made by him. At the end of the trial, the chamber will be convinced that far from doing nothing against the crimes that were allegedly reported to Mr. ssona, he took measures within his capabilities and abilities to prevent or to redress those actions. Mr. President, the court, as I just mentioned, will hear evidence that even Mr. ssona himself was under attack from certain anti-Balaka elements. Now, why would that person be under attack of anti-Balaka elements if he was in favor of their alleged policy of fighting? It only will show this court during the trial that he had no influence of any alleged agitator. And contrary, therefore, to the prosecution case, it will be established that ssona did not accept within the ranks of Comzones, as the prosecution suggests, any alleged crime committed, but he simply did not have the power to remove them from the movement. That is the reality, that was the reality in those days. Mr. President, I conclude my submissions with a document which most aptly will demonstrate our defense case. It's a document called Déclaration liminaire to the Forum de Brazzaville of July 2014. An excerpt declaration at the Forum of Brazzaville. It's to be found document 1 on our list of material. And I ask you to pay attention to page 4 of that document. And please read what Mr. ssona at that time had to say in the days of July 2014. I have two quotations which I think highlight exactly what the essence of our defense case will be about. First is, and I quote from French, "Les patriotes anti-Balaka sont très attachés
The anti-Balaka patriots are convinced
à une société centrafricaine laïque
of the need for a Central African society which is secular,
où toutes les confessions religieuses pourront manifester librement.
in which all religions can live their faith freely.
Dès alors, il nous incombe de sauver le peu qui nous reste
It now falls to us to save what we can
et de nous engager sur la voie de reconstruction
and to take the path of national reconstruction
dans la paix,
in peace,
l'unité
unity,
et la concorde."
and agreement.
Mr. President, this is our defense case. I now finally give the word to my learned friend from the Central African Republic, Mr. Umisi Ngai, to take the floor for the last 25 minutes.
Thank you, Mr. Knops. Mr. Omise Namkeama, you have the floor.
Je vous remercie, Monsieur le Président,
Thank you, Your Honour.
Messieurs les juges.
Your Honours,
Je prends la parole à la suite de mon éminent confrère
I'm taking the floor in the wake
pour
of my colleague,
déclaration de défense
Mr. Knops,
de Monsieur ssona
to present
à l'occasion de cette ouverture de procès.
the concluding comments in these opening statements on behalf of Mr. Ngai.
Monsieur le Président, Messieurs les juges,
Over the course of this trial,
va démontrer
Your Honours, it is incumbent upon the defence
des preuves même de l'accusation,
to show
loin d'avoir été un
that
officieux politique
the proof
un
of the
opportuniste
prosecution
ayant activement pris part
does not demonstrate that Mr. Ngai was an ambitious politician who was actively involved in designing a common plan to establish or to re-establish an overthrown political regime by massacring an ethnic religious community which was recognized as such, but that rather Mr. Ngai was in reality a pacifist, a well-known personality in that society, and that he had been called upon to contribute to implementing a government initiative which enjoyed the support of international partners and which was designed to re-establish peace in the country.
comme postulat
Now, over the course of this trial, the court
où elle n'avait que le statut du territoire de l'homme
will need to bear in mind that
Chari,
since
la Centrafrique regroupait déjà
the Central African Republic was known as Ubungi Shari, it was
à travers des échanges économiques
part of the French Empire and had the status of a territory. Even back then, the Central African country brought together or contained various communities, Muslim and non-Muslim, who lived in perfect harmony together through trade, cultural exchanges, interfaith marriages, for instance. Generations of Central Africans, including Mr. Ngai, had never given a second thought to the ethnic origins or the faith of the people they encountered in their daily lives. Whereas in other parts of the world, societal debates raged on topics such as religious extremism, Muslim fundamentalism, anti-Muslim feeling, In the Central African society, the debate was all about governance, poverty, HIV/AIDS, and the country was very much focused on development, and not at all with ideological considerations. And Mr. Ngai, as the defense will demonstrate, was very much of that mindset. He chose to devote his time and attention to various parts of or various aspects to promoting his country, for instance, in the economic, political, and sports fields. He was clearly of a secular mind and worked closely with people of the Muslim faith, men and women of all social backgrounds, who he simply saw as being fellow citizens of the Central African Republic. Now, the defense will be reminding the court that this is a country which has instability in its genes. The Central African Republic has always had transitions of power which took place through the means of armed conflict, with the exception of the peaceful and democratic transition of power in 2012 when President Ange Félix Patassé took power. The interpreter corrects that peaceful transition of power was in 1993. Other than that, there has largely been instability in the country, such that political analysts have referred to the Central African Republic as being a country of coup d'etat. However, although there have been many assaults on the domestic security of the state, in other words, coup d'etat, some of which have been successful, some of which have been failed, and which have punctuated the history of the Central African Republic, the taking of power in Bangui by the Seleka in March 2013 had various specific features, one of which was that this one was a power grab which caused the whole country to descend into a bloodbath. The taking of power by Françoise Bozizé 10 years earlier, on the 15th of March 2003, involved many of the same players, including Central African Muslims and mercenaries, which had come essentially from Chad and Sudan and which had joined forces under the label of liberators. And a group which also included non-Muslim Central Africans. It is undeniable that the power grab of the 15th of March 2003, which is sometimes referred to as being a patriotic uprising, did cause chaos. It caused looting of businesses, vandalism, and damage to economic, public and private infrastructure, people leaving to find shelter outside of the country, and also the settling of many scores. But this time, the conquest of power by the Seleka led to a disaster. Within a few days, the uproar in which the country found itself led to whole districts and the northern part of the capital of Bangui, and indeed other cities, which were thought to have been favorable to the deposed regime, being the subject of forced displacements, massive looting, one of the victims of whom was Mr. Ngai, and also the victim of gendered and sexual crime, murders, torture, and inhuman and degrading treatment, and displaced and forced disappearances. The loot that was pillaged fell into the hands, or was taken rather, by the Seleka, and was redistributed to in districts of Bangui, which were of majority Muslim population, and also in the northeastern part of Central African Republic, which has large Muslim populations as well, or indeed in the direction of Chad and Sudan. Now, this settling of accounts meant that many people had to flee the country. Now, although the international community listened to the denunciation of abuses by the Seleka in Bangui and some cities, and indeed called upon the leaders of the coup to put an end to the disaster and to reintroduce order, in far-flung parts of the country, where there was nobody, so to speak, to see what happened, rural communities found themselves at the mercy of godless and lawless people who had been given the instruction to claim their due. The people living in the country who had been tracked down by the Seleka and who had been forced into the bush suffered horrendous atrocities, and the defense hopes that the Office of the Prosecutor has received good documentation thereof.
The army has fallen into disarray. The authorities in Bangui had no power over the armed groups because they only heeded the commands of their immediate leaders. Both regional and international forces seemed unconcerned about what was going on, which meant that these young people had to rely on their own instincts to survive and to maintain their dignity as well as the dignity of their families. Farmers, hunters, fishermen, artisanal miners, all these men spontaneously gathered together to form self-defense groups known as anti-Balaka. In the past, they had cooperated with state authorities to fight against cattle rustlers or those who set up roadblocks in some prefectures in the eastern and northeastern part of Central Africa. If Ngai, Your Honours, were called upon to raise awareness amongst the anti-Balaka, it was because of the influence and understanding he had of the young people of Central Africa, thanks to the multiple works and initiatives he undertook in the area of sport. The defense will also show that in the midst of a military political crisis, which had nothing to do with him, he was no protagonist, Ngai, as a true patriot of peace, accepted not to be a defender of the belligerent groups, but rather to work as a mediator, a peacemaker, to bring boys and girls together rather than have them fight against each other. There is no evidence to suggest that Ngai, despite his title of coordinator of the anti-Balaka movement, sought to promote the interests of the anti-Balaka movement above his desire for peace and national cohesion. Despite the many witnesses that have been withdrawn, the prosecution has not been able to hide the evidence that they have brought to the court a man to stand trial despite the fact that he has always acted to promote peace. Mr. President, Your Honours, just like the Central African state, with taxpayers' money and powerful support available, or the international community with its multiple missions and military units, just like they could not solve the crisis which was ravaging the country, Patrice Edouard Ngai, acting as a peacemaker, sometimes putting his own life at risk, and solely relying on his own hard-earned cash, was not able to transform the anti-Balaka movement into a channel of peace as he would have liked to do. Mr. President, Your Honours, it's paradoxical that Ngai has to stand trial today when, through the whole period of transition, there was not a single peace process where he did not actively participate, nor was there any political actor who so militantly and devotedly fought for peace as he did. There is ample evidence of blunders, abuses, bloodbaths, and unrest that would have occurred had ssona not stepped in with his philanthropic spirit and playing his part in an attempt to resolve the crisis which the Central African Republic is still facing. Mr. President, Your Honours, in the Office of the Prosecution in this case will call upon prominent Central African personalities with whom the accused had worked together to look for peace, with whom he had no prior record, but whose false testimony against him is based solely on their desire to keep a person whom they consider to be a formidable opponent out of their arena permanently. The defense is convinced, finally, that during the trial, the Chamber will not accept the prosecution's arguments to prosecute and convict Ngai ssona because as a national coordinator of the anti-Balaka movement, who played a major role in the perpetration of serious crimes against the Muslim community. Crimes where the prosecution has not collected sufficient solid evidence which link the accused to the crimes. Namely, he only intervened in order to mitigate the worst effects. Mr. President, Your Honours, I have finished my presentation. Thank you.
Thank you very much, Mr. Omise Namkeamai. I take it that this concludes the presentation by the defense of Mr. Ngai ssona.
Yes, Mr. President, Your Honours, this concludes our presentation. Thank you.
Thank you. This also concludes the opening phase of the case of the prosecutor against Mr. Ngai ssona and Mr. Yekatom. I would like to thank, on behalf of the Chamber, the interpreters who had a very difficult job. We all hope that in the course of the trial we get accustomed to speak a little bit slower so that they can follow better. And I would also like to thank, on behalf of the Chamber, the registry, who did a great job to connect to different countries. It was not always possible 100%, but under these circumstances, I think it was a great job that they did. The presentation of the evidence will start on 15th March. The court is adjourned.
All rise.